Pamela Council is a New York-based interdisciplinary artist creating fountains for Black joy. Guided by material, cultural, and metaphysical quests, Council's practice embodies a darkly humorous and inventive Afro-Americana camp aesthetic they call Blacksodomy. Through this lens, Council uses sculpture, print, design, architecture, writing, and performance to shed light on under-examined narratives and to make tributes and dedications. Council has created commissions, exhibitions, performances, or presentations for Times Square Arts, New Museum for Contemporary Art, United States Library of Congress, Schomburg Center for Research in Black Culture, Studio Museum in Harlem, Nike, and MoCADA. Council has been artist in residence at MacDowell, Red Bull Arts, Bemis Center, Rush Arts, Mana Contemporary, Signal Culture, Mass MoCA, ISCP, and Wasaya Project. A recipient of the Joan Mitchell Painters and Sculptors Grant, Toby Devin Lewis Award, Rima Hort Mann, Community Fund Award. Council also holds a BA from Williams College and an MFA for Columbia University. And they're currently a studio member at Project for Empty Space. So also on the other side of this conversation, Ms. Lorianne Douglas. Practice focuses on estate planning and business succession planning. In the area of estate administration and estate litigation, Lori handles both contested and uncontested estate matters. Her estate litigation practice includes the representation of heirs, beneficiaries, disinherited family members, executors, administrators, and trustees, and contested probate proceedings before the surrogate's court. Lori has also represents clients in the preparation of family agreements and resolving family disputes, including litigation if necessary. She advises on matters related to prenuptial, postnuptial, and cohabitation for all couples. As a former New York County Assistant District Attorney, Lori possesses considerable litigation experience in both Supreme and surrogates courts. She's frequently interviewed for articles on estate and business planning and is a well-known lecturer at national conferences and continuing legal education seminars. Lori has written extensively in her practice areas and has been named to the New York Metro Super Laureates list in recognition of her work in estate litigation for 2012 through 2021. Lori is a former co-chair of the Diversity Committee of the Trust and Estate Section of the New York State Bar Association. She received her BA from Swarthmore College and her JD cum laude from Syracuse University. Lori is admitted to practice law in New York and Connecticut. So thank you both to these highly accomplished folks for joining us tonight. It's my honor to turn it over to Pamela Council.
Thank you for the introduction, Brittany. Thank you, Ms. Douglas, for joining me for this fourth edition of Is Your House in Order? I started doing this project in 2013, and I started doing it out on the street in Brooklyn as a prompt, a question prompt to people. Is your house in order? Where I also offered them will writing kits, a sort of inventory worksheet, and asked them to start thinking about what happens after death. And this work for me comes out of my family history. You know, being a Black and Indigenous descendant of enslaved people, the relationship to property has been fraught for a long time. As survivors of racial terrorism, there's always something more pressing than getting our house in order. But I'm actually joining you today from the Southampton Public Library in Long Island, New York, which is in my the town where I was born, and my parents were born, and my grandparents were born, and where, like, within my immediate family, we've lost over 13 homes because of poor estate planning. So it's quite bitter, not even bittersweet. It's quite a sad place to be, to have to do this work, but I am a survivor, and so the work must continue. In the past, I've also done Is Your House in Order at the Black Artist Retreat, which was put on by Theaster Gates and Eliza Myrie. I've done it with MoCADA in Brooklyn, and I've done it as a part of the Black Art Incubator at Recess as a performance. And during that performance at the Black Art Incubator, I made this work called Velvet Will. This is 2016. And as I hosted this conversation with artists about how we all feel about estate planning, about writing our wills, about what we leave behind and how we get that organized, I etched into Velvet what I thought was a great expression of my will. I knew it wasn't a real will, but it was like the closest that I could manage emotionally. And it was also a performance. So this is the sort of remnant of that performance. And I'm so grateful to have Miss Lorianne Douglas here with me, so we can read through that will and talk about why it ain't gonna cut it in court, and what we all need to start thinking about as artists, because I know that, you know, for a lot of us, this is the last thing we consider, because we're hustling and bustling and trying to always make new work. But I think it's really important. I wore my Basquiat sweatshirt tonight because people are always talking about his legacy. And we would have known more about what he wanted had he done this kind of planning. So I'm grateful to be in conversation with you to move one step closer to having my house in order. So I'm going to read this Velvet Will, which is on about 17 pages of velvet. They're individual pieces of fabric that the will has been burned into. And as I read, we'll just talk about what's going on here in this document. You ready?
I am ready. I want to thank you for inviting me, and I love your artwork, the Velvet Will, but we're going to discuss why it's art and why it's not a will, but it is a wonderful expression of your intention. So it really is a good foundation for what the information the lawyer needs to actually create the plan. And then we'll talk about what this is, what this isn't, a little bit more about estate planning for the artists at the end, and then see if anyone has any questions. But let's read it, because I love every sheet of this will for different reasons.
Okay, let's do it. And I mean, it should be obvious because we've heard her bio, but I invited Ms. Douglas to come join this conversation because she's someone who is outspoken about understanding the Black family structure and artist needs in a way that is extremely rare among estate attorneys. And I think she's someone who really gets where we're coming from.
Yes, it helps that I'm a Black trust and estates attorney, and there are not many of us. There are a lot more coming up. There are a lot more behind me. When I started, there were really none in the 90s when I looked for a practice area where I could serve my community and really add value. It kind of started, it just happened. I had married an insurance salesman. And so in trying to help him get his practice, I learned about life insurance and points of estate planning. And I thought this would be a real niche practice area for me. And it has been. It's been very successful personally, but really it's fulfilling because it does allow me to help to educate our community. And like Pamela said, it takes a lot of education to go from being the assets to owning the assets and then properly planning with the assets. So we are still in the generations that are recognizing that we have wealth that can be passed on, and we now have to do it properly. So let's start with your Velvet Will, girl.
Let's do it. Okay. I, Pamela Council, born January 17th, 1986, residing in Bronx, New York, declare that this is my will. It is my first will, hope not my last.
And I hope it's not your last either, but that's what that right away causes all kinds of problems. Estate attorneys like myself, we're litigators. And the truth be told, I'm not always hired by, the good child, the person in the right, the one whose will, where, the one who's properly taking care of the will. Sometimes I represent that wrongdoer. Sometimes I represent the bad home attendant who got themselves in the will. Sometimes I represent the estranged child who's been estranged because it was their choice, but sometimes they're estranged because it was mom's choice, and now they're trying to come back in. So all of these things. So if somebody declares this is my first but not my last, that leaves open all kinds of possibilities for other wills being out there. And what you want is one will, and the most recent one in time is the one to be admitted in probate. So every will really starts with, well, this started well, who you were, where you reside. It's important to know the state and the county where we're probating this will. You want to first say, this is my last will, and I revoke any prior, because what we want to have is the one, the one most current. So my first, hope it's not my last. Not good, causes all kinds of litigation right from Jump Street.
Okay. Good to know. Oh,
Kimberly Denise Williams has agreed to be executor. Thanks, Kimmy. First, if I die, find out why.
So one of the most important things about a will is to choose the fiduciary. So while she's agreed to be executor, I would also argue that this language nominates her executor. And once the person making the will chooses their fiduciary, it is very significant in the process, because that means to the court that you pick somebody who you think is trustworthy and efficient. I don't know Kimberly, but I'm assuming she's somebody who gets things done. She's somebody who would know to have to hire a lawyer or an accountant. She would make sure everybody gets what they're supposed to. And that choice is key in a will. And if you have a will and you nominate your own executor, the first thing is that the court does not require your executor to be bonded. And that is a big deal. It's especially a big deal in some communities more than others, because sometimes you have family members that cannot be bonded for lots of reasons. And so if you die without a will and your brother goes to administer your estate, and your brother has had a bankruptcy, or your brother has a judgment for child support, or your brother is a convicted felon, all kinds of reasons why you cannot serve and why you cannot get bonded. So that's a big thing. So you pick somebody. Excuse me?
what does it mean to be bonded?
A fiduciary bond, just like when somebody's arrested, right? And you have to get a bond to get out of jail. It's the same thing. It's a fiduciary bond. It's bonding the fiduciary to cover the beneficiaries if the fiduciary runs off with the money. So let's say, for the sake of argument, you die and Kimberly is your executor, and she goes out and she sells all your artwork and she still takes all the money. Well, under a will, there would not be a fiduciary bond, because the court is assuming you pick somebody trustworthy, so they don't require. But without a will, the court doesn't know whether the person's honest or not. They only know whether you're a certain relationship to the decedent. So therefore, they make you go. And so if when you died, you had no will, but your artwork was estimated at $1 million, Kimberly could have to get bonded for $1 million. You go get a bond from a bonding company, and they put up the $1 million. If Kimberly steals the money, that's to protect your heirs. But Kimberly, in her own right, has to be able to qualify for a bond. And that means she can't have her own money problems and her own creditor issues and her own child support issues and her own, what if she's been convicted of a felony or if she lives out of the country. There can be all kinds of different rules related to the court issuing letters to someone. So when there's a will, a lot less rules because the court is assuming Kimmy is a decent sort.
Here's the thing. This was done in 2016, and Kimmy and I had a falling out.
Okay, well, even more reason why it's great that this is not a will and we have a public record that it is not a will. Because if you have a falling out with anybody, a beneficiary, an executor, anybody, you need to update your estate plan ASAP. Because if you die with the plan in effect, it doesn't matter that you meant to change it. So I just finished emailing with a client who he got married 10 years ago, and his wife, they have 2 little kids. They just came to me for estate planning, and first I asked, their business lawyer for the current plan, and he totally forgot he had signed a will before he got married where he leaves everything to his mother and father. And so now that will is still in effect. And while his mother and father may not know about it, I'm going to tell you right now, if he died today with that will in effect and they hired me, I'm shooting right up at her and I'm going to, the wife wouldn't get totally cut out because there's some states like New York, New Jersey that protect spouses who are not in the will. But I would be shooting up at her and I would end up with half of that estate, even if he no longer meant to leave any to his parents. So it's the same thing. If you don't change your executor, she can just come along and get appointed. And I've had that happen where people have had falling out with people. And the other thing, oh my goodness, if you're married and you name your brother-in-law or your sister-in-law, for example, and then you get divorced, while New York State will automatically cut off your spouse being an executor, it doesn't do anything if you have a miscellaneous family members of your spouse in your will. So your brother-in-law or ex-brother-in-law could be the person administering your estate if you don't update those fiduciary designations. So Kimberly is out and we're going to put somebody else in who's trustworthy and they'll get it done.
Aside from minor mental health issues due to the constant assault of my people, I'm fine. I read somewhere that you have to say that like you're in good health and no one's got a gun to your head or something.
Right. And you would be much better off if you actually had said that I'm in good health and no one has a gun to my head. But from this way, again, for a will, right? For the most part, there's certain estate planning that is lifetime estate planning. But for the most part, when your will or your estate plan is being analyzed and looked at and used, you're dead. So if you say right in it, I have some minor mental health issues due to the constant assault of my people, I'm coming along saying, I think she was a little incapacitated when she made the will. She said it right there in the will.
It's just a little bit of drama, though.
It wasn't.
Right. So that's the thing. That's why you go to a lawyer, because while you and I would have drinks over how we both suffer from the constant assault to our people, we are not putting it in your will. Okay. Oops. So in the will, it is true that you do have to be competent. You cannot be under undue influence. There cannot be fraud being committed. Somebody tells you something, so you leave your will to them because of some fraudulent reason. Those are the reasons that you can contest a will. And so it is important. And the way we cover that competency is really by a witness affidavit. The witnesses to the will sign an affidavit that say, Pamela was over 18, she was competent, she understood the English language. And if English is not your primary language, you should have your will prepared by an attorney in your primary language. So, and then have it professionally translated if necessary to have it admitted into a New York court after you pass. But that's the other thing. I always say to people, estate planning is hard enough. It's really hard if you have a language barrier with your attorney. So you just have to go, you only have to tell me what you want. I'm going to now write it so that it's proper legal form. So again, we're not discussing your mental health. You're perfectly fine. And we're signing affidavits saying you're good.
Okay. Next.
Kimmy, please use my life insurance to pay for my funeral. Have Chev hire that's my sister, Chev, hire the dancing pallbearers. Need the shoulder spin move.
Okay.
So, I want this
like the pallbearers who do the little shimmy spin move at the funeral.
Okay, wow, excellent. Two problems. The first problem is for most people, they have not located their will by the time of the funeral. So shimmy and pallbearers, we're not going to know anything about it because the will is still, you have a confirmed copy. The original is still in my vault. And so there's a separate document. In New York, it's called an appointment of agent for bodily remains. And so in that's where you would put your sister in charge of your bodily remains, and you would say what you want about your pallbearers or whatever you want. And so she would have that. You give it to her before you die. Don't leave it, in your desk drawer with the copy of your will, but make sure she has it. And that's how we get what we want at the funeral, by people knowing what you want. And one thing I will say, a lot of people think they don't need that appointment of agent for bodily remains. It's a good thing to have because you would be amazed how people disagree about funeral arrangements. Now, I personally would also love your dancing pallbearers with the shimmy shake, but some other people might not think that's so appropriate. So by saying what you want and having your sister be the person in charge, then that gets it, as opposed to leaving, parents or somebody else who you might think will find that distasteful or not want to do it or whatever. That's number one. Number two, life insurance normally has a beneficiary designation, and it goes by the beneficiary designation, and therefore it passes outside of the will. So things that have beneficiary designation on them, or they are jointly owned with right of survivorship, they're in trusts for, or they're pay on death, those are all going to go outside of the will. So it's really important for those things to coordinate with the will and the other estate planning. So for example, you say, Kimmy, please use my life insurance to pay for the funeral. Well, if you leave Kimmy on the life insurance as the beneficiary, if Kimmy is honest and trustworthy, she will use it for the funeral. But if not, and especially now you've had a falling out, you forget to change your will, and now that is just to Kimmy. So remember, it's not going to be in the will. So Kimmy is just going to take the death certificate and contact the life insurance people and collect her money. So if it just says Kimmy as beneficiary, that's hers, and she can do with it what she wants, unless it actually is for a burial fund or it says that it's something for that. People do not have to contribute the life insurance money to help the rest of the estate. That is so important because so many people have more than one child, especially, and they leave this life insurance policy to this one or that one, thinking they're all going to put it together. Well, I'm going to tell you right now, that never happens. People take their own money. And I won't say never, it rarely happens. They take their money, they say, Mom meant for me to have it. They go off with it, and now the executor, whoever, is left holding the bag.
Can the life insurance be left to the
Trust?
Yes, you can always make your will or trust or whatever the beneficiary of the life insurance policy. And we do that. Sometimes, people have a lot of life insurance. You need to have an irrevocable trust to get the death benefit out of your estate for estate taxes. Or you have minors who can't inherit at all. Children cannot legally inherit under 18. So if you don't have a vehicle like a trust set up for the child, you have to go through the court system and get somebody appointed the legal guardian for the child. And then that money stays in the court system until the child's 18. So sometimes you want to have the trust as a beneficiary, but for a lot of people, life insurance is your liquidity in an estate. A lot of people don't have a lot of money. And so life insurance is a place with just a death certificate and a beneficiary designation. You can collect that money. So we often do leave life insurance beneficiary designated. So person dies, you get the death certificate from the funeral director within, a week or so. You can collect that life insurance money right away. If it's in the will or the trust or whatever, there may be a delay in the administration process.
Okay. Wow.
Thank you. I didn't know
That was a separate thing. Okay, what's next?
Right, there's a lot in that one sentence. Okay.
Oh, please bury me in the
Black church section in Southampton.
Again, that needs to be in your appointment of agent because it is possible, oftentimes, so for example, let's say you had your will. We don't give our clients their wills. We keep them in our offsite vault in Chase. So that way the original, is available to go through probate. But let's just say, you pass, your family does everything, they bury you, they do, and then they go through your papers. That's when they find your copy and call me. So again, if you have anything about burial or your funeral, anything in this will, it may be too late by the time anybody sees. You may be buried someplace else. So again, anything about happening before you die or immediately to your death, about your body, your funeral, your wake, anything, that needs to be in a separate document that your agent has.
Agent. Okay. Next. Oh, then pay my debts.
And then I say siblings are the closest relatives, which
Okay, before we get to the siblings or the closest relatives, I love that. What page are we on of your will? We on page 7 of your will, and you say, then pay my debts. Well, guess what? Your debts get paid first.
Oh.
It doesn't matter where you say or what order you tell people to pay your debts under the law. The executor, if there's a will, the administrator, if there is not a will, the first thing they must, first of all, before you can do anything at all, period, the funeral director has to be paid. You cannot if you have a will, you don't need a paid funeral bill. But if you have an administration, you absolutely need to have a paid funeral bill because the court wants to make sure there is not a funeral director out there not getting paid. That is the first person that gets paid in every estate. So whether we have a will or not, we always ask the very beginning, I need a paid funeral bill before anything. So the first debt's always paid is the funeral director gets paid first. You can prepay your funeral so you can pay them ahead of time. Get today's prices for the funeral.
I need to become a funeral director.
Yes, you do, because they get paid. They get paid right away. So then the fiduciary's job is to marshal all the assets, but then you have to pay debts in the proper order, and you're not going to be surprised to know who is number one. Taxes. Okay. So first, you got to pay the IRS. You got to pay New York State or wherever the state you live. You may have to pay other states where you have property tax, whatever. your issues related to taxes, estate taxes, income taxes, everything, that all has to be paid. And the decedent's final income tax returns have to be prepared. And if the decedent had not prepared their income tax returns before they died, it becomes the fiduciary's responsibility to file any outstanding ones if you know about it. And then after you pay your taxes, then real estate taxes, then you get to debts of the decedent. So I can't tell you how many times I have people die with literally no money in the bank. They own a home and they have $100,000 in credit card debt, just paying monthly. And their kids seem to think that dies with their parents. It does not. Your debt has to be paid. So if you have no other way to pay that, then the house would have to be sold to pay those debts. Okay, so your debts are all paid. And then after your debts are all paid and the estate administered, now we get to distributions where you say siblings are the closest relatives. So I assume that means your parents are deceased. Is that what that means?
No, my parents are alive. It just
Means that like my
what?
siblings are my favorite people. I don't know. My parents are alive and they're both remarried. So I have like 4 parents.
Okay. So then this is very good because again, clarity is the key. While your siblings may be the closest relatives to your heart, legally they are not. So if you are unmarried and you have no children, then legally your closest relatives are your parents if they're living, or the survivor if one is deceased. So the order of succession, it doesn't matter how you say what you say you want to do in your will. In New York State, they say that's fine, but before we, distribute the way you say in your will, the process allows for your closest relatives to come in and contest if they want to, because but for this will, they would take. So for example, if you wanted to leave to your brothers and sisters, that's fine. Your will could say, I leave in equal shares to my siblings. Here are their names if they're living, and you list them. But if your parents are living in New York State and you had to have that offer that will to probate, they would have to either sign a waiver agreeing that the will could go to probate and that their children disinherit them basically, or they get their right in court. So they could hire some lawyer like me who can come along and ask for certain depositions right off the top and say, I want to take depositions of the witnesses to the will and make sure that, she wasn't incapacitated on that day, because that makes no sense that she cut out her parents over her siblings. So that's the reason. So you want to say, if it's your siblings, that's fine. But if your parents are living, you might want to say, I don't make any provisions for my parents because they don't need my money. Or because, we've had a discussion or something so that, to reduce the likelihood of litigation. Some people will get a lawyer just because they don't really know what their rights are. And there are a lot of bad lawyers out there. They will take your money and tell you, oh, I'll do this, that, and the other for a contingency. And they're not going to do anything because there's nothing to do. They're going to lose. But they'll take some money and then just lose. So you have to be, clear. And then if you are going to disinherit, even if it's unintentional, then you want to put in why. And as a general rule in estate planning, it doesn't make sense for assets to go up. Assets should come down. So it is regular and routine that people disinherit their parents over their siblings or their nieces and nephews or whatever. So it's not a big thing to do it, because that's what we tell you. Don't have money travel up, have it travel down. But you need to say it so that it's clear. Because siblings are the closest relatives. I would think that meant your parents were both deceased.
Damn. Okay. Next.
Oh, I
Together,
love that.
together we are the council. My primary beneficiary My primary beneficiary. All unsold artwork, licenses, and rights go to the council, Cheverly Keyshawn Council and Paul Nathaniel Council III. That's my siblings.
Okay.
So I'm just naming them.
Right. So naming them. And again, this is more a clarity issue because I love that together we are the council. And I was like, the council of what? The Council of New York, the Art Council. And so you want to be like, this is clear. So what you're really saying is that you are leaving all of your artwork, you know, if you have intellectual property rights with the actual piece, if you have digital rights, if you have, you know, prints, licenses, things out on consignment, the whole shebang, you're saying I leave it to my 3 siblings, right? Is there 3 of them?
2 siblings, my brother and sister.
Oh, your sister and then your brother, Paul. So now, but then what? Let's see, do you say anything? What happens after you leave it to them? You gave it to them, they have it outright. How do they decide who gets what pieces? Are they supposed to put it in trust and hold it together? Do they have kids? Like a lot of things will happen. And one thing with artists is, I don't know, but for example, if you were my sister, I would want your velvet will because it's what I do. I would be like, oh my God, I want that velvet will. We went all around the country talking about it together. I have so much attachment. Now, when you pass, your velvet will, boom, worth $1 million. And so now Sotheby's is going to auction off your velvet will. And they say it's a minimum of $1 million we expect. Your brother's like, you know, I really liked her a lot, but this velvet will doesn't mean that much to me. And I'd really like $1 million. So you now have a conflict right away because some things are sentimental, some things are valuable. And if you don't say specifically who, what, or how, it's gonna be a fight because I'm gonna say I want this will because it means a lot to me. And our brother's going to say, I want this because I want it sold and added to, you know, to the split. So
okay,
very clear as to what is supposed to be happening with this stuff, who gets what should they try to sell, what should they keep, what should they try to donate to charity if they can, because then again, the estate gets all kinds of tax benefits, you get charitable deductions or whatever. So detail.
So that needs to be part of
my art inventory that like, you know, this goes here, this goes there. This is something you should never sell, like only loan it. We have to keep this.
Right. That's the thing. And it's in the materials at the end. For the artist, the single most important thing is to inventory the art, to catalog it, to date it. The more I have, you know, to date it, to sign it, to date it, to title it, to write a blurb about it, the more you have about the artwork, how it was created, if it needs to be repaired, what the materials were, the more you have about the artwork, that increases the value on your death, but it also allows for your fiduciaries to know what you want. I have a client right now with a lot of an artist with a lot of his own artwork, and he could really use some liquidity. And, and so it's hard to say to people, you know, maybe if you just sold some of this artwork, you can get some money. But that's the reality. And so while we're doing this estate planning, while he's not dealing with any of the artwork, what he now kind of has to, in the inventorying, is starting to think about, okay, well, would you want somebody to sell this? Would you want somebody to try to donate this to a charity? Would you want this to be put on a consignment to a hotel and, you know, license it, all those kinds of things. And hopefully that will help the fiduciary, but it also helps the process of him saying, oh yeah, maybe I could try to sell some of these things now to raise up liquidity, but also what, you know, who gets what, and there are some things as with artists where family, you know, certain things you just want to stay within your family, maybe.
Okay, what's next?
With the advice of Roman Jackson, foundation manager, mad exuberant, digital experts and socio-spiritual advisors, Dana Liss, art advisor, and Allison Bland, research partner. So I'm listing all these, I'm giving all these people titles.
Okay, for what? What's happening? Because so far, I don't know why you're giving them any titles, because you gave your brother and your sister all your artwork. So what they doing? You gave them the artwork. What are these people doing now? I'm just saying, your brother and sister are like, see ya, what do we need these people for? They just split it up and go about their business. What's happening now?
Yeah, I guess my idea was that my
brother and sister would get my brother and sister would have the ultimate say about the work and what happens. But these people are people I trust, who know my process, who they could go to
for trying to figure things out.
Right. So then you have to say, what are you giving? You're not really giving these things to your brother and sister. What you're really doing is you're creating a trust, a concept, or a foundation, something where what you're doing is you want to give your brother and sister this artwork for them to then monetize after your life and put that money or whatever, the artwork, hold it in some way, and then have these people help them so that they know that they're doing the right thing. And then the royalties money that comes in, they split or as added to the trust for future generations or whatever. But the stuff itself, the artwork, what you're really saying is you want it to stay in some form until there are no descendants of yours, for example. Then maybe it all goes to a foundation, or maybe it goes to a foundation. But you're not really, because by giving it to them, then they literally can just each take whatever and go their own ways, do whatever they want. So that's why you need a trust, or you need something. And one of the reasons, it's in the back, and I'm sure we're running out of time already, but one of the things I talk about is instead of will-based planning for artists especially, or musicians, people that have digital assets and intellectual property, artwork, that kind of thing. And for regular people too, who have, specific accounts, revocable trust-based planning is really advised, because that's the kind of trust where you put all your assets in it during your lifetime as the grantor. Then you are the trustee and you make all the decisions about the trust during your life. And you are also the lifetime beneficiary. But on your death, your assets are in this trust. The disability trustees are set forth if you become disabled. The death trustees are set forth. And then the first trust for you breaks into the trust for the next generation, or whatever you want to do. And one of the benefits of that kind of trust is once you set it up, you can just put an assignment. I assign all of my artwork into this trust. And then once you have your catalog, then you attach that. But if you should drop over dead right after signing that assignment, all of your stuff is in there, and your trustees would be able to administer the trust without probating a will.
Okay. I think that's
what I was trying to build.
Right.
Because really, I'm leaving my brother and sister with a job. I'm not really leaving them with work.
So that's what I'm saying. So that's a perfect thing. So if you had enough artwork where you could, establish a foundation, and then what they would be the directors of the foundation, and they get a salary for monetizing this artwork and monetizing the foundation, and then doing whatever charitable work they're going to do with this. That's perfect. If that's what you're really trying to do, that can be set up in your trust or in your will. That can be set up. And if you haven't set up a foundation, you can put the language to say to them, they have to set up the foundation. But you just want to be sure the language is clear, because if you give it to them, then they don't have to do what you want. But if you give it to them in trust, then they have to do what you want, or you tell them to set up a foundation or whatever. So that can be done as long as you tell them to do it.
okay. Next slide. Oh, I said I'm unmarried, I'm
Childless.
And-
That's
and-
kind of
and-
self-explanatory.
It is, but it really should, this should have been slide number 2. Right after the first slide that says, where, your name and that you revoke any prior wills or codicils and where you reside. The very next section we usually have is your family, because under the law, your next of kin are required to get this notice. So if you say, I'm unmarried and I'm childless, then that lets us know we don't have to be wondering if there's a spouse out there. We don't have to wonder if there are children out there, and we just go to your parents and then to your siblings. So that's very important. We have that in every will. What is a person's status at the time of making the will? And if you do have children, we prepare all the estate planning documents to automatically include any afterborns, adopted, any of that. And we also have, definitional language about what makes somebody your descendant. So, if you have a son and a daughter, for example, and your daughter has a child, your daughter is your descendant, we're pretty sure. But if a son has a child and there's questions about paternity, then your descendants under our plan, that child will only be your descendant if there is an order affiliation, or he marries the mother, all the things that you can do under family law to make him, he open and notoriously acknowledges the child, but the child might have to bring a proceeding to say, yes, here's my, my father was this person, it's my grandmother, she came, she was an artist, like she would have to do all of this kind of work to say it. So it's very important to say, what is your status at the time of making the will in terms of married or having children, because those are the only 2 people in estate planning. You're either married, you're either married or you're not, you're either with or without children. That's the only status in estate planning. I can break you down from that, married or not, with or without children.
Okay, next. Oh, and then I'm declaring I
have no real estate, no car, no pets. Art, digital, intellectual property will go to my siblings.
Again, so this would now all be in the trust, and we do have specific, since, especially since the internet and digital assets, because now everybody has digital assets, not just the artists. Everybody has Facebook, everybody has something. So we now have all kinds of provisions related to digital assets so that your fiduciaries can not only, collect, monetize, get royalties, but things like taking it down. You want to take your, Instagram down after you pass. So that's the other reason your fiduciaries need access to your digital assets.
Okay, what's the next
page? Oh, the council will establish
a foundation of my name to benefit artists like me, with the mission of telling the Black history of the Hamptons, where I am, prevention of child abuse, and what goes on the next page? Protecting the legacy of Pamela Council.
So in fact, so they could set up a foundation, and that would be the mission and for them. And so either if they were so focused and they actually wanted to do it themselves, they could really do it themselves. And if they were not so focused, they could do, different kind of donor investment funds. They could just donate to organizations that do these things. And so that kind of is left up to them how much they actually do. Because some people have family members that really want to do it, want to run the foundation, want to do all fundraisers, and other people are like, I really, I understand my sister's charitable intentions, but I just assume write a check to somebody else. And one thing I just want to add, when you're saying you were in the Hamptons, it is very sad what's happened with Black people as their properties in the Hamptons and in Sag Harbor, right? Because those were really Black communities, and those historically Black communities, because I have represented estates And I represented a Black man's estate out there where his family just could not get along about that property. And they sold 6 acres of prime real estate out there. And a white developer came out and he built 9 huge houses on the 6 acres. And we go out there. I just went out there recently, and my friend who has a house out there knows the family. He took me, he's like, you're not gonna believe, as we know the song it was sold for because of the family infighting. And now looking at, I mean, it's millions and millions of dollars.
Yeah, I mean, the way, it's hard for us to keep property here. And I know so many people for whom that's the case, and they're like, can't make an agreement, so they just sell.
Right.
And
Black families in the South, I mean, all over the United States, Black families have lost thousands and thousands of acres in generational transfers because, like you said, nobody can agree. And the biggest thing is paying the taxes, right? Somebody pays for a while and then somebody else pays and then somebody stops, and the next thing you kind of just lost the property, or, you know, by the time you can get the family organized, you sell it for much less than what it was really worth.
Yeah, it's heartbreaking.
So is that the end? That's not the end of your will, though, is it?
Okay. We got a few more.
Oh, the parents can have their stolen silverware back.
That's because you stole it from them?
Yes, I stole it from them. And
if I die before them, they can take it back. Unfinished art is not for sale, but written works can be published.
Okay. So again, these are directions, but real clearer directions, because unfinished art is not for sale. You know, I might argue as the trustee or with the foundation, you know, if it's going to create value for the foundation, I might argue like, oh, she really meant that some of that could be sold if it was going to increase the value of the foundation.
So I need to have,
or if you're saying unfinished work is not for sale, then what can we do with the unfinished work? Could the unfinished work be part of the, you know, Pamela Council display? Could unfinished work be part of the Pamela Council documentary? Like, you know, there's stuff to be done. And that's one of the things in the checklist. Artwork, I understand it's subjective even to the artist, but even stuff you don't like could have value one day. So you don't destroy anything. Even if you think, I didn't finish whatever, as you're doing your inventory, if you don't, try not to destroy anything. I know the whole world, you can't keep everything, but if you have to, we advise to talk to your people on your list, 1 or 2 of them that know art, that know you, that know your story, that know what you're trying to tell in the future. Have them look at it. And if they say, I don't know, you should keep that because it fills in this piece, then keep it. If everybody says, no, it's crap, you can throw it away. But, you know, when your artwork, your bad artwork is way different than my bad art. So keep that in mind. Unfinished art should have value. Yeah. Especially once you pass, right? Once you pass, you know, most artists, or whatever kind of artist you are, musician, whatever, the value of your estate goes up and your work goes up like the second pass.
I know. Yeah. It's a whole nother thing. Okay, next.
We'll try to
get
through these. I know we want to get
to the next section. My art is only to be sold with an agreement to publish on my, I have no idea what this means. My art is only to be sold with an agreement to publish on my work and exhibit good stewards only. Oh, never work with an agent of the dead. The council is a vamp-free zone. So like those like CMG or like someone, an agent that only represents dead people, who's like kind of goes after people who misuse the license. I think at the time of writing this, I didn't want to work with them, but I don't feel that way.
I understand, right? And one of the reasons why that happens is because there is no plan, right? And so those people, those kind of agencies, they know how to monetize estates. So they come in and offer to monetize it for you because they know how to do it. But if you have your own people in place that can monetize it, then you don't have to work with those people, but you have to have, and again, that's the problem. It's the problem with most people is that they don't do their estate planning, but some people's estate, because of the complexity of your assets, and even though it might not seem complex, if it's artwork, it's complex. You really have to be more organized because it's not just about collecting your accounts or selling your house and distributing out money. It's about really monetizing a legacy if you can.
Mm-hmm.
Next up. Please maintain my
Annual established 2016 donation of lotion to the Black art students of Williams College. Their moisture will impact their futures. This is a gift, legacy gift.
Okay, so does somebody know? I don't know what that means. Does somebody know what is your annual donation of lotion?
Honestly, Williams College has
Not accepted it. I've tried to create a lotion fund for Black art students there, and they said that my fund is not large enough at $1,000 a year.
Okay, so this is a perfect example. So this would be part of your foundation. They could take a piece of your $1,000 and donate it to whatever, or do something for your lotion. This is specific. This is to prevent future ashiness, correct? Because I'm down on the lotion thing. But if you were serious, you should be detailed, because some of us need, heavier lotion than others. Some of us have, need that Gold Bond eczema formula. So you better be detailed. But again, anything and something like that, a perfect example is you can make a donation to, you could say, I leave $1,000 to Williams College for the students. And if your fiduciary goes to give it and they say they don't want it, okay, they don't have to take it. It would come back in your estate. But they could take your $1,000. And I've never heard of somebody turning down any amount of money. But on a regular basis, they might not want to do something sustainable. But you could, you certainly can set something up with a charity before, or you can, within your foundation, you would say you want a piece for X, Y, and Z.
Okay, great. Yes, we got to make that happen.
Okay, burn my clothes in Shinnecock, so like on the reservation. Someone keep the spam bank. Bo can have the couch. Oh, I already gave it to him. Fuck the rest of my junk, put it in a barrel. No body parts leave. I don't know, I don't want to be cut up.
Okay, so I don't know whether you can burn your clothes in Shinnecock. If you can, that could be done, but there might be some prohibition to doing that. People often, they have things, dump my body in the East River. We can't do that, but to the extent that, you want to pay money to go out to sea, to blah, 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 then maybe something could be done. But if you could do that, they could do that. The couch, I guess you gave away everything, right, to your brother and your sister already.
Yeah.
And when you say
couch.
When you say nobody needs no body parts, now I'm not sure if that's referencing organ donation, but if one person would, so there are two things, right? You can do organ donation, and that organ donation for transplant, human transplant only. People can say you can take my organs, but only if they're going to transplant it into a human, not for science. Or you can also leave your organs or cadaver or whatever to science. So my father, for example, he's filled out a thing to leave his body to Columbia Presbyterian. When he passes, they'll pick him up and use him in the school, whatever. And then they'll send us back the ashes, and the ashes will be will be buried in the crematorium garden next to my mother's ashes. And so you certainly, if the organ donate again, for organ donation, some of these things you want them to be in your, not your death documents, but before death. So organ donation, for example, if you feel that way, that should be in your healthcare proxy. We haven't gotten the chance to talk about these things, But in addition to estate planning, you need to plan for disability. So if you can't make your medical decisions, you need a healthcare proxy. If you don't want artificial life support, if you're terminal, permanently unconscious, or irreversible brain damage, and life support will only prolong your natural dying, then you want a living will. That's where you would put about organ donation, or you want to stay at home if possible, those kinds of things. And then you also need a financial power of attorney in case you can't make your financial decisions, so somebody can make your decisions for you if you're during your incapacity. Once you die, those documents no longer are in effect.
Okay.
But certainly those documents, and you would say about, I don't know about any other body parts. Nobody should have them.
Okay.
I can't speak to that, but organ donation is a real thing. And again, that should be on your license in a medical directives where people can get it before not in the will when it's needed.
Yeah.
So anyway,
I changed my mind about that. Yeah.
Okay, because I think they want us to finish up on the will and then take some questions. Oh, we're at the end.
Get a Black makeup artist. So this is again that appointment of agent for bodily
Yes,
remains.
you would put that in the appointment of agent. And if you don't have anyone, I am going to recommend my cousin, because not only is he a makeup artist and stylist, but he does do he does do work in funeral homes. And that's an actual thing. You have a makeup artist in the funeral home, and he has one very famous story where he had just finished a lady before the funeral, and the family came in and they looked all around and they were like, "Where's the body?" And he said, "Right here." And they looked at her and said, "Oh my goodness, she looked better than."
That's terrible, but great.
It is terrible, but tell the funeral home you want to be looking good.
Yes, very important.
Okay, no ash monsters. Yeah, you know how sometimes they be messing up the makeup. Thank you. Love Pamela Council.
And
that's
then,
the velvet will.
And that is perfect. And the only thing about this, it is not a will, because while it is signed by you, it is not witnessed by two people, at least. Two people. Very few states require three, but we only do it with two witnesses. New York, New Jersey, Connecticut, Florida, most states, Georgia, they use two. But it is important that not only is the will witnessed, but affidavit is also signed at the time by those witnesses saying that you were competent and over 18 and those things. If you don't have those witness affidavits attached to the will when it's done, you have to locate those witnesses when the person dies. So if Pamela does a will this year and I don't have that self-proving affidavit on the back, and she dies 40 years from now, and somebody contests, objects, asks any questions about this will, I'm going to have to go out and find those witnesses. So it's very important to have that attached at the time. But then that's it. So that's those are the things that make it a will. Those are the things that make it not one. But if I think if Brittany, I don't know if she wants me to talk about these things or if you want to take questions, because I see 37 things in the chat.
Oh my gosh.
Yeah, if you want to take, we can move to questions, or if you want to just walk through some of these basics, up to you, what you're feeling like.
Well, I can walk through, because these things are literally very basic. What we're talking about is, doing an estate plan that not just for when you die, but when you become disabled. And the purpose of all of these documents is so that your loved ones can properly take care of you the way you want if you're disabled, and to pay your bills and make medical decisions consistent with how you would make them. And then for when you pass, to make sure your assets are organized properly, they go to who you want, the way you want them to, that, whether they're in trust or whether they're outright, whether your expenses can all be paid. It's really a matter of coordinating everything. And if you don't do that, I mean, it's always messier. It's always more expensive. It always takes longer. It's just a matter of how bad it's going to be. And that's going to depend on your own personal circumstance. So you can go to the next one. You know what? I think everyone can read this, but estate planning can really, it allows you to do some aspect of all of these things. Not everything, and not every plan can do everything. So for example, we do a lot of trust-based planning, whether we put trust in a will or whether we do standalone trust. We are a firm that really says, put everything in trust. That is the best way to create generational wealth, to have creditor protection for your heirs, all those things. But some of those trusts, and the basic one, the revocable trust that I talked about, that doesn't help you for tax planning, right? So a lot of people come to me and they say they want to trust, and they also don't want to, pay any income tax, pay any estate tax, pay any capital gains tax, pay all these taxes. I'm like, okay, that's not that type of trust. So you can do, tax planning, but it's not, if you want to pay less taxes yourself, or you want to avoid your own creditors, you have to do certain kinds of irrevocable trusts, and they have to be done well in advance of having creditors. So you can't do everything with every kind, but pretty much you can really do everything that you want to and need to. I always tell people, unless it's something really illegal, anything you tell me you want to do, I can put it on paper. And one thing that is important to point out, that it is a will. That is the only legal document where you can nominate guardians for your minor children. So even if you do revocable trust-based planning, we're going to have these trusts that fall out for your children after you die. If you have minor children, and anybody, we always do a will just in case. But if you have minor children, we must do a will, because that's where you would nominate guardians in the event that both parents, or one parent's not available, or both parents die. That's the document where you have to nominate guardians for minor children. It can't be like a baptismal certificate or something like that. That's the only place where you can do that, is in a will. I think that's good. We could go to the next one. So these are kind of your basic estate planning documents. Like I said, first, everybody should have these, and the disability documents, they are available online. So I do not in any way recommend anybody to do their own estate planning, their own will, or their own trust. It's just too complicated. As we can see, Pamela, it's a great way to express your intentions. But if you do it yourself, you could really just make a mistake that could be very costly, and just kind of unnecessary mistake. So I advise everyone to go to a lawyer for wills, trust, and the like. But a durable power of attorney, right? That's the financial appointment of an agent if you can't make your financial decisions. The New York State, first of all, every state has its own forms. You can go on title companies are usually the best place in New York. Judicial Title, I use all of their forms. And in January of 2020, the New York State durable power of attorney completely changed. The whole form changed. So if you have an old one, or if you don't have one, you should update your power of attorney. You can get the basic form online. Like I said, Judicial Title has them online for free, and you can complete it yourself. If you have detailed assets, or you need to do more complex stuff, then you probably want to talk to a lawyer if you become disabled. But the general power of attorney, you can complete at witness, have it notarized yourself. The healthcare proxy, the same thing. That doesn't need to be notarized, just witness. That appoints somebody to make your medical decisions whenever you can't make them. You do not have to be end of life, just you're unconscious, you're incapacitated for some reason, you can't make your medical decisions. that appoints somebody legally. And in that healthcare proxy, while the healthcare proxy appoints the agent, the next slide, I think, is the living will. That is the document that says your desires if you're at end of life stage. And that document, we don't have the clients give to their proxy or give to anyone. You hold that one back. And if there comes a point where the healthcare proxy and the doctors and everyone is saying, we are at this point, do you want us to remove Lori, or do you want us not to, resuscitate if she has cardiac arrest or whatever? That's when the healthcare proxy can bring out the living will, and it helps the healthcare proxy make the decision, because then they know, okay, here's her living will. I'm now acting the way she wants. And it's such a difficult decision for your loved ones. That's the reason for the living will, is to back up to help the proxy make the decision and to know when it's time to actually make that decision. And then the guardianship nomination, like I said, there are different times when guardians can be nominated. The one we most think of is for minors. If both parents die, or if there's a single parent, who's going to take care of the child till they're 18 physically. And then also property guardians. If you don't have a plan with trust, somebody also has to be appointed to take care of the child's money. But when you get old and become incapacitated, right? Elderly parents, not only do we prepare healthcare proxies and powers of attorney, but for adults, we also prepare a nomination of guardianship, so that if something happens and a hospital brings a guardianship proceeding against you, or children fight about who's taking care of mom and somebody goes to court, if a person signs a nomination of guardianship when they're otherwise competent, unless it can be proven in court that the power of attorney or the healthcare proxy, the nominated guardian, is doing wrong, then that person, either there'll be no appointment of a guardian, but if the court says, yes, a guardian is needed because their incapacitation has gone beyond what we think a healthcare proxy or a power of attorney can do, then the court should appoint the nominee, unless the nominee has proven to be otherwise a bad actor. So that's very important for when you're an adult, you can nominate somebody to be your guardian as well. And then I think the last two slides are really about, so this one is about, beneficiary designations, joint ownership. You want to make sure that everything that you have that can have beneficiary designations has either a person or your trust or your will. And you really want to make sure that coordinates with the rest of your estate plan. You want to be especially make sure you have beneficiary designations, a named person on retirement plans, a 401k, a 403b, an IRA, any investment accounts that are pre-tax dollars. You want to have a named beneficiary, because that money you have not paid income tax on, and you don't have to start paying income tax until now the age is 72. At 72, minimum distributions have to come out that you have to pay the income tax on. But because you don't have to pay the income tax until the money comes out, if you have a named beneficiary, then that minimum distributions can be drawn out for 10 years. If you don't have a named beneficiary and it goes into your estate, all the income tax is going to come due in that first year. It could be up to 40%. So it's really important to have somebody on that. And then after you do your planning, you might change it to a trust or whatever, but just in case. And if you have minors on an IRA, they can stretch even longer than the 10 years at this point. Life insurance is the other thing. It's another thing that passes by beneficiary designation. You could have your estate or your will or your trust as the beneficiary. Just remember, you can't readily collect that money unless you do something about the will or the trust. Whereas if a person's on it, they get the death certificate, they go to the life insurance company, they collect the money. It's often life insurance that provides you with that immediate liquidity that you need in an estate to pay bills, especially real estate related bills, because people don't think about the fact that when mom passes living alone in her home, the mortgage may still be due, the real estate taxes are going to come due, the utilities have to stay on, all of that thing. So you have to have some way to pay for those things until you can, marshal other assets. And sometimes there aren't a lot of other assets besides the life insurance. So it's very important and it's also just important to have life insurance for a whole lot of reasons, for estate planning, for income, to pay estate taxes. It's just, life insurance is really a good device. People don't recognize the importance. And I think the last slide is really about a last will and testament and trust. Those are your foundation documents in an estate plan. Most people think of a last will and testament as the definitive thing. But as I said, we do a lot more, especially now with the courts are backed up, with COVID has really changed things. People are just sort of unexpectedly dying very young and not prepared. But we're doing a lot more revocable trust-based planning, where the clients fund their trust during their lifetime, and then you operate as trustee. So that way on death, everything is organized. And with that revocable trust-based planning, more and more clients are asking us, once it's done, to sit down with their children and explain it. So that way, when they pass, the children are already up and running on how it works. So I think those are the slides. I don't know where we are on time.
I think that's all the slides.
Thank you.
That was wonderful.
Well, are there questions?
Oh, yes.
Loaded up?
Many questions. We'll take about 10 minutes here to go through them. For starters, I'll read one out here from an attendee that asks, does it matter that your assets are not real property, as in real estate, but you have valuable collections, i.e. a valuable collection? So Ms. Douglas.
Yeah, I mean, it matters in that you have to do something about it, but real property is real property, and your stuff is tangible personal property. So your collections, everything that's tangible personal property, something has to happen to it. Something, if you pass, just like real property, your brokerage accounts, life insurance, bank accounts, car, whatever, something has to happen with every single thing. So you can plan for tangible personal property, just whether or not, just like Pamela, she said, I don't own any real estate, but she's got tangibles that are important to plan for.
Okay, thank you. Another question. This person says, Con Ed, student loans, and mortgages do not have to be paid if that person transitions, correct?
Wrong. Absolutely not. First of all, real estate is different from other assets, because real estate passes with its expenses and debt. So my estate plan leaves my house to my son. So my son he would take the house subject to the mortgage, subject to the real estate taxes, subject to the utility bills. Okay, so is a perfect example. I have life insurance, right? My son is only 24. So I have this estate plan that ultimately leaves most everything in trust, but I do have life insurance. I have some life insurance that's just going to pay to him directly. One of the reasons for that is so that he has immediate money. He has like access to my bank account, right? He could probably also get into my bank account illegally online and access money. But the reason is because he is gonna need money, no matter how sad he is, he's gonna need money within 30 days maximum of my death, because the mortgage has to be paid, the Con Ed has to be paid, the water bill has to be paid, We heat with oil. The Robeson oil, they could sell oil, and that has to be paid. So these things have to be paid. If you don't pay a mortgage when somebody dies, they don't care. Doesn't matter. If you don't pay your mortgage within 120 days, bang, you go to foreclosure, automatic. It's the same thing when someone dies. If they don't get the mortgage payment, you go to foreclosure. If they get the mortgage payment, they don't even care. So I have plenty of clients, their adult children pass or their parents pass or whatever, and they just say, Lori, just let me know when to comp, but otherwise they just pay the mortgage. As long as you get the money, they don't notice, but then you have to do something about it. Student loans also, everything. Your debt has to be paid, but because there's a priority of debt, if you run out of money, then the person doesn't get paid, right? So if a person died with student loans and they owe the IRS, they owe their taxes for that year, or they had a deficiency, and so they owe the IRS some money, and they owe New York State, and they don't own a home, and they only had enough money, they only had enough life insurance to pay for the funeral, there's no money in the bank or anything. Now the student loan doesn't get paid because there's no money to pay the student loan. But if there are assets, then they will come after you. I mean, it's not so much now, but there have been times when literally I would not answer my office phone at all because it's blowing up all day with collection agencies who are calling me about, DCM collections, this collection, that collection, this person died, owes American Express. I'm like, hey, you guys are way down on my list. I might not have any money for you. You can keep calling. If one day we got money, I'll pay you. Or if you want to take 30 cents on the dollar today or something like that, we can work it out. But otherwise, stop calling me. Visa, you're last on my list.
One follow-up from this person, they're asking, so we are paying this debt out of the deceased funds, not our personal?
Yes, no, not your personal. Nobody has to pay anybody's estate debt. So that's the other thing, quite frankly, depending on how an estate is structured, there could be no estate to pay the debt. So, you have clients, I have clients that have bank accounts, they have their children, they have one child. Person that has one child, they have their child joint on their bank account. They have their child joint on their deed to the house, all this stuff. Person dies, boom, by operation of law, everything has passed to the child. No estate. No estate. Now, where do you get your money from? That's a different story. That is now a problem because there is no estate to get the money from. Now, I'm not saying they're not going to come after you for a long time. It might be, but there is no estate. That's different. And creditors are different too. But one creditor, the super creditor, the IRS, they can get to everything, including like 401k. If I owe the IRS money and I put my son as beneficiary on my 401k, they can even come after that. So the super creditors you have to watch out for. But some people won't get paid, but it's only out of the decedent's estate. You have no obligation unless you guaranteed a credit card or something like that. You have no obligation to pay out of your money.
One quick one that says, since this webinar is being recorded, is this evidence that Kimberly is no longer the executor?
I mean,
well, it doesn't matter because that would not be admitted to probate. So if Pamela were to pay, I would not be able. Now, not to say you could not. We have had wills on napkins and handwritten wills. We have these things where you could, under certain circumstances, you could try to offer them for probate, but this wouldn't qualify. We already know because it's not witnessed by two people. So we wouldn't. And so what would happen if Pamela died right now, if there is no will, her, both her parents, so her parents are the people that have priority to letters of administration in her estate because she's unmarried with no children. But if her parents didn't want to serve, they could renounce to her siblings. So let's say she passed and her sister said, oh, I'll handle everything. And so her parents could renounce, her sister could get letters of administration and administer the estate. And then at the end, if she went to distribute it to the parents and they said, oh no, we know Pamela really wanted you and your brother to get it, they could give it back, or they could renounce, or they could disclaim. We could do stuff, they give it back. Or they could say, thank you very much, and it's a shame that Pamela didn't leave a will, because then you all would be getting this, but we are. So.
I gotta get this will done.
Let's see, do we want one more question? Just one more to close it out. Let's see. Ooh, so many good questions. Okay.
Oh, I see somebody has written that says, I have a sibling.
Yes, I'll read that one. If I have a sibling, the only line of blood succession that I want to leave absolutely nothing to, do I need to clearly disinherit in any and all documents?
Yes. If your sibling, so if your parents are living, right, and then you pass, it would go to your parents. But if your parents are deceased, and you absolutely, you must disinherit your sibling. And I would actually suggest you are the perfect person for a revocable trust. Because if you have a fully funded revocable trust, there is no need to probate a will. So we always have to do a will just in case, but we have lots of clients who we do revocable trust-based planning, not just because it's more organized or whatever, but because they don't want their estate to have to go through probate because they're disinheriting relatives, or they don't want to have to look for relatives. They have missing siblings. So I have clients who are like, my brother has a substance abuse problem and we have not seen him in 20 years. So now, we can do a search, we could do death records, but if we just can't find anything, that person is a perfect candidate for, let's just do a fully funded revocable trust. And then when you die, there'll be no need to have to even look for your brother. So you have to disinherit. And I suggest that even if you're disinheriting people, not because, if you're going to disinherit your brother, you would want to say, I'm disinheriting him because we have no relationship or whatever, reasons known to him or whatever it is. But if you're disinheriting somebody like Pamela disinheriting her parents just because she'd rather have it go to her siblings, then I suggest you actually disinherit them. But to say, I'm not leaving anything to my parents because, my parents don't need anything and they understand I'm leaving it to my brother and sister or my nieces and nephews or whatever it is. Because that person is, going to have an opportunity to contest. So I had a client who had a very extensive estate plan where she was leaving everything to her brothers and sisters. Her parents were both very ill. Both had been in nursing homes, very ill. Then she got sick with cancer. And her brothers and sisters did not help her at all with her illness or with the parents. So a tenant moved in with her and that she became very close and she helped her with her illness and she helped to take over taking care of the parents. So my client called me up and she said, I want to change. I want to completely disinherit all my siblings and I want to leave everything to this woman who's moved in with me and has been helping me, blah, blah, blah. Her siblings knew about the will. So I said, okay, fine. And she was going to have an operation. So she's like, Laura, I need to come in right away. So I said, okay, come in, 2 days from now. I was like, okay, we'll make the change. I'll make everything. You can come in and execute it. But in the meantime, you should write a letter to your siblings and say why you're disinheriting them and everything. So we have it in the file because there's a good chance they're going to contest because they know they were getting everything. She had a big house in Rochelle and now they're being totally disinherited. So when she came in, we signed the new will and everything. And at the end, I say to her, oh, do you have the letter for me? I'll keep in the file. And she was like, oh, well, I do have a copy of the letter for you, but I mailed that letter to every one of my siblings. So there is no question. And I read that letter. Oh, yoy. There was no question. She meant to disinherit them. She talked about each one of them and what they hadn't done and this, that, and the other. And when she passed, they first contacted me because they said, well, we understand, we were in the will. And I said yes, but she changed it. And the brother said, well, and I was like, but didn't you get your letter? And he's like, excuse me. I said, I know she sent you all a letter and she gave me a copy. So don't you know why you're disinherited? And he was like, oh, okay. And so they didn't go forward with anything. They didn't know that I knew the story. So important disinherit.
What is this in the chat?
Can we get
I agree.
TV show?
I agree.
I
Bring it on, bring it on.
Christopher Jordan, you want to help us greenlight that? Thank you both. Thank you, Ms. Douglas. Actually, let me pull up one more slide for folks to copy down. And I should also note that we will share these after this webinar closes, because there's a lot of great content here enclosed within this information. Here's where you can reach out and contact Ms. Douglas and her firm with any more questions on this.
I was going to say, and if you have general questions and you email to info@drestateCouncil.com, we'll try, one of us will, me or one of my partners will try to respond to your general questions. But also, if you do want to do estate planning, you can email us and let us know you want to start, because our process starts with sending you a questionnaire. And that can help you to get organized. So even if you don't work with us, you can complete the questionnaire and then do your planning with somebody else. And if there are artists on here, please, please, please start the cataloging of your artwork. That is the single thing. I have artists as clients where we have these very extensive plans, and then I'm like, how's the cataloging going? And they're like, well, I haven't gotten to the storage room. Well, I forgot about the warehouse. Well, and so that's the single thing that's hard for your fiduciaries is figuring out the art collections itself. So please, please, please catalog.
Thank you, Ms. Douglas. So grateful
to speak to you. This is wonderful.
Thank you. And Pamela, we'll be speaking about your will very soon.
Yes, we will be. Absolutely.
I promise. All right, guys.
Thank you both.
Thank you so much.
Thank you, Ms.
Good night,
Douglas.
everyone.
Thank you, everybody, for joining us. And we'll see you soon. Have a good night.
Good night.
Night.